Well, today was motion hearing day in the Donna Adelson trial. As the trial is coming closer and closer, jury selection has been changed from September 16th to September 17th. Actually, what was a little bit funny here is it actually started off September 17th and then switched to September 16th, and now it got moved back to September 17th. So that's when jury selection is going to get underway. It's going to take a few days before the actual trial begins. And good news, I will be putting out a poll to see whether the viewers and subscribers want me to actually live stream the entire trial, giving you real-time analysis. If you want to get a little bit of a taste of what that is like, I did live stream today the motion hearing, giving you my real-time analysis of what was going on, explaining the different arguments that were being made and the different procedures and what the judge was saying. So you can go check that out. We did live stream the motion hearing today. This is going to be a recap of what happened today in that motion hearing. And there was a whole bunch of motions filed, a lot of motions filed, as is typical in this type of the magnitude of this type of case when you have these attorneys. So let's jump right into it. So first, the court went through the defense's motions in limine. And actually, the first motion that he decided to talk about and let them argue was the motion to dismiss. This is after everything is said, this may decide the case. So let's hear the motion to dismiss. If we grant the motion to dismiss, then we don't even have to waste our time with all of the other motions that were filed, right? So they jumped into the motion to dismiss. We did an entire video breaking down the arguments of the motion to dismiss. Essentially, simply put, the motion to dismiss was based on something called pre-indictment delay. Pre-indictment delay is the fact when you have the government sitting on a whole bunch of charges or sitting on charges for a bunch of years and deciding not to charge you until all of your witnesses' memories fade and all of your witnesses and documents are lost and you can't get in touch with them and you can't find these documents anymore or they're not available. So if the government is just sitting on your case for years and years and years and not charging you with any crime so that they can have a tactical advantage because they have all the evidence, it's all in their locker rooms. And for you, you don't even know that you're going to be charged. So you don't even know to keep these witnesses on your contacts. So that was an argument that was being made since it was such an extended amount of time from the time that Dan Markel was murdered until the time 9 years later when they actually formally indicted and charged Donna Adelson. So the case should be dismissed outright. Now you need to prove two things. The first thing that you have to prove is substantial prejudice. And this is something that I pointed out while this was going on in the live stream. You can see me. I pointed this out that Dan Rashbaum actually made the argument that the first thing that you have to prove is prejudice. And really, it's actually much more. As a defense, you have to prove substantial prejudice. And that was one of the arguments that was not Georgia Koppelman. It was Sarah Dugan. She argued that, first of all, it's not prejudice, it's substantial prejudice, and that wasn't proven. And the second thing that the defense has to prove is bad faith, which means that if the defense was just forgot about this, the government forgot about this case, they forgot to prosecute the charges. It was just sitting in someone's file and they forgot about it. And then later they say, hey, we never followed up on this case. We have to make some arrests. And there's a long delay. Well, in that case, it wasn't bad faith. It was just you sleeping on the job. That's not considered bad faith. Bad faith means that the prosecution did it for a tactical advantage. That's why they did it. So if they can prove that, number one, substantial prejudice, number two, bad faith, then you may have some merit in this motion to dismiss. So that was Dan Rashbaum's argument. And essentially, one of the most important parts where it came down to is that Dan Rashbaum said, look at their exhibit list. Their exhibit list is identical to the case that was Katie McManaw's trial in 2019. So if this is the exact exhibit list, this is the same exact evidence that they've had since 2019, why are they waiting till 2023 to arrest Donna Adelson? This is the exact same evidence. They didn't learn anything. The only conceivable reason that they waited is for a tactical advantage. And if that's the reason that they waited, so then this case has to be dismissed based on pre-indictment delay. And we explained all of the law behind it in our previous videos on this. Go check that out. So that was essentially Dan Rashbaum's argument. And the argument back was the fact that actually Katie McManawa gave a proffer in 2023 And in 2023, that's when she actually mentioned that Donna Adelson stopped by Charlie Adelson's house that night. And there was a drop off of cash. That was the allegations. Now, if the government didn't learn that till 2023, well, now they have much more evidence and stronger evidence in case they were sitting on the fence before thinking, is Donna Adelson involved? Is she not involved? I don't know. We have some evidence. We don't have some. But if this is the actual clincher, the fact that she dropped off money that night at Charlie Adelson's house, well, then that's what the government argues, that we just found out in 2023. We were not just sitting on all the evidence for a tactical advantage, and there's good proof of that. So some of the argument to that was that Don Rashman says, oh, that's actually not what Katie McManamon testified to, or that's what, or not what she testified to, and not what she said in her proffer. So if she didn't say those things, so then the defense's argument is much stronger. If she did say those things, so then the prosecution's argument is much stronger. So what the judge said is that he's going to take it under advisement, and he's going to look over Katie McManamon's testimony and her proffer. And if really some of this information came out in 2023, well, then that would be a reason that this motion is going to be denied. And anyway, most likely this motion is going to be denied. I mean, it's going to be very hard to imagine that the judge is going to grant this motion. Now, even if we think about this motion to dismiss, there's some the alternative to this was that the defense moved the court and asked the court that even if you're not going to dismiss this case, but you should still preclude the text messages, and there's going to be a witness who testifies about the pattern of the phone calls from Donna Adelson to Charlie, from Charlie to Katie, and Katie to Sigfredo, and you're going to see this pattern of when they make these calls right around the time of the murder. From May, they have these records from May 2014 through the day of the murder, or through a few months. They have a few months of these records showing the pattern of the phone calls and the text messages and how they go back and forth. So that's a big part of the evidence showing that there's obviously some conspiracy going on here. Everyone's together on this. And the argument that, and the defense is arguing that entire testimony should be excluded based on this pre-indictment delay. So even if you don't want to dismiss the case, but we want that evidence precluded. So the judge is going to reserve his ruling on this. He's going to write an opinion about it, and he's going to look over some more evidence, and he's going to make his final opinion about this. So again, like I said, it's most likely going to get denied. Whether he's going to somehow limit the testimony of this individual, we'll see, but most likely this motion is going to get denied. Okay, so now that we moved on from the motion to dismiss, then we moved on to some of the other motions in limine that the defense filed, and then after we went through all the motions in limine that the defense filed, then he let the prosecution argue their motions in limine that they filed. So we'll break it down one at a time. Next thing was the motion to move courtrooms. They wanted to move courtrooms. The defense wanted to move from a much bigger courtroom to a much smaller courtroom. And they made some arguments about that. Really not such great basis in the law for this. There was no case law about this. There's no rules, no statutes. And that's one of the things the judge asked the attorney, as I always mention in my videos, you got to bring authority to the judge. If you want the judge to do something, you can't just say, judge, do it. You got to show the judge the authority that allows him to grant what you're asking for. And if you don't do that, then the judge is most likely going to say no. Now, if you can show somewhere that this is in the discretion of the judge, okay, so the judge has discretion, and we're just asking you to use the discretion in our way just because, we're asking to be nice to us. So you could do that. But here, again, this is a discretionary matter. There's no real case law about this. There's no statutes. There's no rules. And this is what the judge brought out when he was talking to Alex Morris. Do you have any sort of, authority on this? And he says, not really. It's kind of like just a fairness thing, due process, that kind of that type of argument. And eventually the judge denied that motion. Like everyone was really anticipating that the judge was going to deny that motion. Then we moved on to the wiretapping. The defense wanted to preclude the wiretapping that they through the bump, and they had they had all these recordings from conversations that Donna had with Charlie, and all these we've heard these conversations already. We've heard that, and all came from a wiretap. Now, part of the argument was the fact that the wiretap came only, first of all, way after the murder. So they're arguing that the basis for being able to get a wiretap was stale. So it's already too long from the murder to actually now start wiretapping people's phones. That's number one. Number two, they argued that there was no necessity to wiretap. And this is all based on some case law, that there's no necessity to wiretap these the phones. You don't need to do that. So since it was not necessary, they could have investigated this case in other ways. They didn't need to wiretap. Wiretap is a real big intrusion on someone's privacy. And if you're able to conduct the investigation without doing that, it's kind of like a last resort. And on this, the prosecution argued back that it's not really an accurate statement of the law if it's reasonable for the circumstances to get a wiretap, and any other avenues of investigation wouldn't have worked, or they're not reasonable, or they're too dangerous, or things like that. Then you are allowed to wiretap. And she developed the record, and the judge said, we're going to reserve ruling on that specific issue as well. Then there was the defense filed a motion for a jury questionnaire because of the publicity of this case, because there's a lot of channels like myself. And by the way, if you haven't yet, please subscribe and like the channel so we can continue growing and bringing this message and this analysis to more people who are looking for it. So the next thing was that because of this jury question, because of the publicity of this case, so the defense wanted a jury questionnaire to go out to all potential jurors and make it very clear. Have you heard about this case? Do you know who Donna Adelson is? Do you know Wendy Adelson is? And we'll be able to cut through a lot of the time-consuming part of jury selection by asking them all these same questions over and over and over again. And eventually, the prosecution actually opposed this motion, and the judge denied this motion for a jury questionnaire. All right. Then there was another argument. The next argument was the fact that Donna Adelson, before she was arrested, she did not want to get investigated or give any interviews to any police. So they don't want any sort of evidence of that coming out, and that also was granted. And then an interesting part was the wealth evidence. There's going to be some evidence that whether she's an expert or not, this is another part that the prosecution listed her as an expert, and Dan Rashbaum said she's not really an expert. She's just going over the Adelson's wealth and all their bank statements and things like that to show how extremely wealthy they are. Well, he argues that evidence should not be admitted, because what does it have to do with the case? And here Dan Rashbaum argued that we're not going to dispute the fact that they were able to make these payments, or that they actually even did make these payments. We're not going to dispute that they didn't make these payments. We're not going to dispute that they have the means to make these payments. But why do we have to let the jury know that they have $10 million in their bank account? What does it have to do with the case? All you're going to do is perhaps enrage the jury against these very wealthy people who think that they can buy themselves out of all their problems. So let's not allow the jury to find out that information. So the judge said that he granted it in part and denied it in part. He granted in part that they're not allowed to say that what the bottom line is, like that these are extremely wealthy people. They have a yacht, or they have 12 vacation homes, or whatever it is. You're not allowed to say those things, that they have all these millions of dollars, but you are able to argue, the prosecution is able to say that they definitely had the wherewithal to pay this type of money for a murder for hire. The suggestion to $1 million, or to relocate for $1 million, or this money to pay hitmen, that they completely were comfortable enough to be able to do that, so that they are able to argue. Then we had the Jeffrey Lacasse part, and this is always interesting, because if you remember the Charlie Adelson case, this was a big argument. Jeffrey Lacasse he testified that at one point he was talking to Wendy, and Wendy told Jeffrey Lacasse that Charlie looked into all options and how to deal with the Markel problem, including hiring a hitman. Everybody remembers his testimony, and he said most likely he's going to say it again in this trial, or he's going to try to, and or certainly the prosecution is going to try to get him to say this stuff. And he said that she was dead serious. It wasn't a joke. It wasn't a joke about a TV. It was not funny. It was absolutely serious, and he actually was scared about it. His heart his heart jumped. Whatever. So it was a serious conversation, and obviously that is very, very damning evidence to come out. And Dan Rashbaum argues that this should not come in because it's hearsay. This is what he argued in the Charlie Adelson case. And the judge actually in that case initially said it's not going to come in, and then eventually he allowed it in. And we're going to explain the two different theories to get this testimony in. So Dan is arguing, the defense is arguing that it's hearsay because Wendy Adelson, if Jeffrey Lacoste is testifying about what Charlie Adelson told Wendy Adelson, that is so many levels of hearsay that it should not be admitted. Every single level of hearsay needs an exception in order for it to be admitted. Well, the argument is twofold. Number one, the prosecution argues, this is Georgia Koppelman, she argues that number one is that we know that co-conspirators' statements, even though technically would constitute hearsay, but if they are co-conspirators, then those statements are allowed in. So here you have statements between Charlie and Wendy, which can be co-conspirators in this, and they can come in through those statements. And number two is that it could impeach Wendy Adelson. If Wendy Adelson said that Charlie never mentioned to her the idea of hiring a hitman, or never in a serious tone. He was always just joking about it, like it's cheaper than the TV is cheaper than hiring a hitman. Well, in that case, then you should be allowed to introduce what Wendy Adelson told Jeffrey Lacoste about what Charlie Adelson told her as impeachment. Because again, you're not offering it for the truth of the matter asserted. You're not offering it to show that this was actually what Charlie told Wendy, and that's for the truth. But it's actually saying that Wendy, who is on the stand now testifying and saying that Charlie never, ever was serious about it. Now you're getting testimony from Jeffrey Lacoste that no, actually, he was serious about it at one point. So it's just being offered for impeachment and not for the truth of the matter asserted. So therefore, that's why also it should come in. Now, that's why eventually in Charlie Adelson's case, it did come in. So here the question is going to be again, in Donna Adelson's case, is this going to come in? And Dan really doesn't want these statements in. He's really arguing that it should be hearsay. And the judge actually said he's going to take it under advisement, which is interesting. I think that's interesting because up until now, he's already heard all these arguments. He's heard all these arguments in Charlie Adelson's case, and he allowed that testimony in. So what more really is there to consider about whether he's going to allow this testimony in? So maybe he's having some second thoughts about it. Maybe he's thinking about it again. That's a very important part of the case, to say that Charlie was not actually just joking about it, right? And the minute that he's serious, this actually becomes a real conspiracy. So if this is the only way that it can get in, it's going to be an interesting, very, very important part of the case. So we'll see what the judge does with regard to that ruling. All right. Then we had some testimony, some motion about Wendy Adelson's testimony. And the defense wants to preclude a number of different parts of her testimony. And that is, number one, about the book, that book that she wrote about this couple who was in this terrible marriage, and she's stuck in the marriage and basically sounds like it's really about herself. But she argues that it's not about herself. Anyway, so that book, does any evidence of that book, is that relevant at all? Should that come in at all? That's number one. Number two is the name changes, the fact that she changed the name of her children, or last names, and also the issue of not letting the grandparents have visitation, that she would try to keep the kids away from the Markell parents, Dan Markell's parents, and the idea of Dan Markell's parents advocating so strongly for this change of law to give grandparents visitation rights in the state of Florida. So here what the judge did was that he actually denied the first two parts, which is about the book and the name change. That is able to come in because it really shows a little bit more about what Wendy was really feeling, can really bring out that this is really all a conspiracy here because she's saying how she feels in the book. And also the name changes, that's significant. So he's allowing that to come in. But the other part, the part of the grandparents not having visitation rights or things like that he said he's granting the motion. All right. Then we have, again, the jailhouse recordings. And we've been hearing about the jailhouse recordings for a while, right? So we have these recordings between Charlie Adelson and Donna Adelson after Charlie was convicted. So we're talking about after Charlie was convicted, all of those conversations. Dan Rajmal made the argument that Donna Adelson's recordings could come in, right? She's a party opponent. Her conversations, her part of the conversation could come in. But all the things that Charlie said in those conversations are hearsay. So therefore, they should not be allowed in as evidence. So if the prosecution wants to play the jailhouse recordings, then it should only be able to play the parts that Donna is talking, not the parts that Charlie is talking, because it's hearsay. And you can't argue, you can't tell me that this is co-conspirator that this is a co-conspirator's statements and therefore they should come in because co-conspirator statements are not hearsay, because this is after the crime. After the crime, it's not a conspiracy anymore. So again, they're charging her with conspiracy to, first degree murder, conspiracy to commit first degree murder. That's it. They're not arguing. They're not charging with anything else. So therefore, anything that happened after the murder, any of these conversations should not be considered part of the conspiracy anymore. So therefore, he says that any part about Charlie Adelson and those jail calls should not be admitted. And here, the argument back was the following, which is a nice, interesting way to think about this, is that when you are in, let's say one part of the conversation is allowed in. So Dan is already admitting that Donna Adelson's part of the conversation or what she's saying is definitely admitted. But let's say she responds to some of the questions that Charlie's asking her. And she says yes or no, or I don't know, or maybe. And you don't even understand what the context of the questions were. Well, then how is that hearing from her yes, no, maybe so? How is it going to help the jury understand what she's saying yes to? So again, it's not the argument here is that it's not going to be offered to show for the truth of what Charlie is saying, but it's being offered to show the context of what Donna Adelson is answering in affirmative to, or what she's answering in the negative to. So that part should still be admitted. And also something called adoptive admissions. Okay, adoptive admissions is also an exception to the hearsay rule. That here, if my hearsay, what my comments are allowed to come into trial, if they're admitted, they're admissible, then you have to, then whatever the person who I'm talking to is telling me, and I admit, I take on that, whatever that person is saying, it's an adoptive admission. I'm adopting what that person is saying. So therefore, even though it's not technically the words that I speak in my mouth that are coming out of my mouth, they're actually the words that this other person is saying, but I'm adopting them. I'm admitting adoptive admission. I'm adopting those words to be my own. And therefore, we look at it as though Donna Adelson is actually the one saying the words that Charlie is saying, if it's an adoptive admission. So here are circumstances, these are cases, these are situations in which you can't just say, well, we have to ignore everything that Charlie said because they're hearsay. If Donna Adelson's words are allowed in, which they are, then some of Charlie's words should also come in as adoptive admissions or to show context to what Donna Adelson is talking about. So that also seemed to have been what the ruling is going to be with the judge with respect to those conversations. So again, it's going to be depending on what exact conversations they're having. The judge said, obviously, if they're talking about how bad the jail food is, then that's not coming in. But if there's something to do with this case and it falls into these categories, he's going to allow it in. All right, then there's the argument about the autopsy photos. This is always an issue in murder cases, that the defense never wants the jury to see the autopsy photos because they're really, really graphic and horrible, and it's very hard to unsee, and it makes you feel sympathy, anger, it gives you all these emotions, and you don't want the jury basing their rulings, basing their findings on their emotions. So the defense is always arguing once they see these pictures, they're just going to vote guilty no matter what. And of course, it's part of proving the case, and this always gets into the same type of argument where the prosecution generally wins on this case because they have to prove a death, they have to show a death. So this is all part of the evidence, and they're not overdo it. They can't show 150 pictures of it, but they can show a few pictures of it, and that's essentially what's going to happen in this case. Also, then we also have one of the most important motions that the defense filed was this evidence of flight. This evidence of flight that Donna Adelson is trying to fly and flee to Vietnam, a non-extradition country that she was Googling before. And this is their argument that it should not be allowed in. Why not? Why not? Well, the reason for that is that this is the argument that Dan Rashbaum made from the podium, was the fact that the way that you look at this is, something that he didn't mention, which he mentioned in the motion actually, was if there's a very big time delay. Well, actually, he did mention this, right? If there's a big time delay from the time that the crime was committed till the time that you were attempting to flee, right? So then how can we connect it to if you committed a crime 10 years ago and 10 years later you board a flight? How is that looks like you're fleeing? This crime was allegedly committed 10 years ago. So again, there is this idea of delay. And this is clearly in the case law that if there's a significant amount of delay between the time that the crime was allegedly committed and the time when the person is attempting to flee, then that would be considered not evidence of flight. of consciousness of guilt. So that was one of the arguments that Dan Rashbaum was making, that Donna Adelson was not, first of all, so much time between, and also she's doing everything in the open and in the public. This is something that an innocent person would also do. If this is what Dan Rashbaum wanted to look at it, that if this is something that an innocent person would do, so then we can't automatically assume that this is consciousness of guilt. And an innocent person, what would they do? They would be very open about their plans. They'd put in their diary. They'd put it in their notebooks. They would talk to their friends about it. They would apply, they wouldn't do any secret names. They would just use their regular names and apply to this through for passports and for visas and talk to Charlie about it. So she was being so open about it. So it looks like an innocent person's acting. So this is not evidence of consciousness of guilt. So that was the defense, that therefore all of this should be precluded, or evidence of flight. Now, obviously, if you get this out, this would be a tremendous, tremendous win for Dan Rashbaum. However, the prosecution argued back that it's a good argument. Perhaps you can make this argument to the jury. You can say that she was just going on vacation, and you can say that she just happened to book a one-way ticket because that's what she always does. And you can argue whatever you want. But again, it doesn't go to the admissibility of this. It all goes to the weight. It all goes to how much weight is her flight. Is her flight really just a vacation, or is it not? So that was, and also, again, she was Googling right before non-extradition countries, and she booked a one-way ticket. So, and it just so happens to be right after Charlie was convicted. So, okay, these type of arguments, the judge basically said that, okay, these type of arguments you can make, but I'm not going to not allow the prosecution to argue that this is consciousness of guilt. There's definitely evidence showing that this is consciousness of guilt. And yeah, there is a little bit of a time delay, so you'll argue that, but that doesn't go to the admissibility of this. It just goes to the weight of it. So that was essentially all of the defense's motions in limine. So now let's move on to the prosecution's motions in limine. The prosecution first argued that Luis Rivera's gang affiliation and prior bad acts should not be allowed in. That was one of the motions that they filed. So the gang affiliation is very important for Dan Rashbaum. Why? Because Luis Rivera is a key witness for the prosecution, because he's laying out everything what happened. He's giving us the whole story of the conspiracy here. And Dan Rashbaum wants to argue that this is a guy who is not just affiliated with any gang. He's affiliated with the Latin Kings. The Latin Kings is not just a street gang. It's not just a few block gang. This is a tremendous gang. And in fact, he was the leader of a certain portion of this gang. So Luis Rivera is very high up. So the Dan Rashbaum wants to argue that the reason, this is what he's going to argue, the reason why Donna acted in the way that she did, perhaps not going to the police, is that she's really genuinely scared of the Latin Kings. Who wouldn't be? And if this is not just a few rough teenagers that you just go to the cops and say, tell them to bug off. This is some of that. You can't just go to the cops and be protected. They have such long tentacles, and there's such a huge gang. If they put the word out, you're done. So maybe this is also why he's going to use to explain that she didn't go to the cops and why she acted the way that she did. But that's only because he's affiliated with such a terrifying, scary gang called the Latin Kings. So this was his argument back. So in terms of the bad acts, and there's some other bad acts that Luis Rivera engaged in. Obviously, he's not the cleanest guy in the world. So for that part, the judge said, okay, well, the bad acts is just classic character evidence. We're not going to allow that in. In terms of the Latin Kings, he's going to reserve ruling on that, because that may actually be relevant to the defense's theory. Depending on how involved he was in the Latin Kings and how much Donna Adelson knew about that, that's going to be an important part of the defense's case. So he said, I'm going to reserve ruling on that. If you do want to mention it, just have a sidebar with me if you feel that it's important to talk about. All right. Then there's 22 caliber bullets that were found at Premier Health and Fitness Center, which is where Dan Markel was before traveling home. And they found these 22 caliber bullets, which you can technically argue, well, maybe somebody from the club followed him and has those bullets there. So the prosecution argued that should not be allowed in, and the defense agreed with that. They're not going to argue about the 22 caliber motion. They're not arguing that Luis Rivera and Sigfredo Garcia weren't the ones that killed him, Dan Markel. So there's no point of arguing about these 22 caliber bullets. So that was also, they're not going to mention anything about that. Then there was the idea of Luis Rivera's mental health. And again, these are ways that the defense wants to attack Luis Rivera when he's on the stand to say, number one, he's part of this gang, and he's obviously not very credible, and he also has some mental health issues. So he's all over the place. Can't remember stuff. He has panic attacks. He has schizophrenia or bipolar or whatever they want to argue about his mental health. So they argued that his mental health should not be allowed in, and that was also granted. Now, they also have this investigator. The prosecution has this investigator called Jason Newland. Jason Newland is so essential, this is the prosecution argues, that he's so essential to this case, and we really need him in our conversations. We really need him to be with us the entire trial, that even though normally you have a rule to sequester the witnesses in a case, here we want him with us because he's just essential to the case, and there's some case law about that, and the defense essentially said that's fine, as long as we also are able to have our investigator in trial as well the entire time. All right. Then there was also some evidence of domestic violence between Luis Rivera and Jessica Rodriguez, and the defense may want to bring that out to show the jury that this is just a really, really terrible guy. Luis Rivera, he just has problems with everybody in all relationships, and he's not someone to be believed. And so they're arguing that this is like, prior bad acts as character evidence, and it's not going to be allowed in, and that is what the judge agreed to as well. We also have the prosecution filed the motion for the use of headphones, that there's going to be a lot of audio played in this trial, as we saw in the Charlie Adelson trial, and therefore they want to equip the jury and the judge and the defendant and everyone who needs with these earphones, and they want to be able to use that without a problem, and the judge granted that as well. Now, there was also the use of demonstrative aids. And this is where it gets a little interesting, because there were some arguments here that when you have audio, and this is the way it works, the audio is the evidence. So when you have all these wiretappings and you have this audio of the conversations between Donna and Charlie or whatever, any audio that you have in the case, the audio is what is the evidence. The audio is the evidence. And a lot of times you'll see in trials that they also provide the jury with transcripts of that audio. Sometimes it's just hard to hear, and you would rather see the transcripts, like captions on a video. Maybe putting the captions on this video. So it's just an easier way to follow along if you're the jury. So the prosecution wants to be able to provide transcripts and some other demonstrative aids to help the jury understand and follow the conversations of the audio. So again, the transcripts are not evidence. Only the audio is evidence. Transcripts do not go back with you to the jury room. So this is the argument that the prosecution wants to be able to help the jury with the audio. So the argument from Dan Rashbaum is that some of the audio is really very unclear, and from different snippets, the Dolce Vita and the Matsuri, those places you can't really hear the audio so well. So how do I know that this is an accurate transcription of what's going on? So therefore, he argues some of the audio, fine. I don't mind having the transcription there, but some of the other audio that you can't really hear so clearly, I don't want that to be considered a demonstrative aid, because it's not. First of all, it's not helpful. Second of all, it may not be an accurate transcription. So that was his argument back, and what the prosecution's response was that if there is somebody there who can authenticate that this is actually what was said at that time, even though the audio is not so clear, but I was there, I can tell you that this is what was said, and this is what the transcription says also, so then it will be allowed as a demonstrative aid. So the judge essentially said, okay, so for the wiretaps, that's going to be okay, that's clear. Transcripts are clear. There's no question about that. When it comes to the other things, Matsuri and Dolce Vita, that is going to be subject to authentication. I mean, someone's going to have to come in and say, yes, this is what was said at that time, and this is the transcripts. And if it can pass authentication, through cross-examination and everything, then we will allow those demonstrative aids in as well. Now we also move on to statements to elicit sympathy for the defendant. So the prosecution is nervous. They're foreseeing that the defense may argue that Donna Adelson was really not treated well in jail. And because she was not treated well in jail, just feel bad for the woman. Now, of course, they're not going to argue it like that, but they're going to try to pepper in some sympathy that the jury should have for Donna Adelson because she was treated so terribly in jail. So this is what the prosecution wants to make sure that the defendant is not going to do. But Dan Rashbaum argued back that, well, I can see how it can be relevant, because this could also go to show why her flight to Vietnam is actually not consciousness of guilt. It's not consciousness of guilt. This is just her not wanting to spend her days like we're going to hear how she spent in jail, that she was just being treated so terribly in jail. That's why she didn't want to go. Not because she's actually guilty. She just knows that she's being unfairly framed and unfairly charged, and she's going to be stuck in jail with all these guards who are not treating her properly. And that's why she was actually wanted to take a flight to Vietnam. So that was part of Dan Rashbaum's argument there. And the judge says, okay, look, I'm going to grant this motion. You're not allowed to mention this idea of how she was treated in jail. If you feel at some point that it's necessary, maybe the prosecution opened the door, or for some other reason you feel that it's necessary to argue and bring in some of those facts that she wasn't treated well in jail, then you're going to have to bring it up with me at the time, and then maybe I will revisit it then. There was one other motion that was filed, which is like a little bit untimely. It was a late motion that was filed, and it has to do with Sergeant Corbett, about some of the testimony that Sergeant Corbett is going to be talking about with text messages and arranging text messages in a certain way. So it just came in late, so the judge said I can't really talk about it. The prosecution didn't have a chance to look at it. I just saw it myself just yesterday, so it's just too late. I can't entertain that motion now. So he set a date for September 6th to hear that motion. I think that's also another date for a final pretrial to see if there's any other issues that came up. There's some more depositions to go on, so it could be that there's other issues that will arise that they have to take care of on September 6th, but that is going to be the next hearing here, September 6th. And we are moving much closer to this trial. So September 17th is literally right around the corner. We actually may be live streaming that trial. I'll put out a poll, see what you guys think about that, or you can leave me a comment in the comments if you would like me to live stream this actual trial and bring you real-time analysis like I did today on the motion hearing. Well, that is going to be it for today. That is the recap on the motion hearing for Donna Adelson. Please, if you haven't please subscribe, like. You can join the brother sidebar membership. Join that. A very easy, simple way to help support the channel. We have some merch also to help support the channel. We're putting literally a lot of work into this stuff. So hopefully any way that you can help would be great. Easiest way is just to like and subscribe. So please do that. And without any further ado, we will see you next time.